Welcome to The Explainer. Today we're breaking down a fascinating constitutional puzzle that went all the way to the Supreme Court. It's a case where a single word, even a single letter, threatened to completely upend the balance of power in our government.
So you've got one constitution. You've got two houses of Congress. The question seems simple enough, right? How many representatives should they get? Well, this very question sparked a major legal crisis, challenging the makeup of the incredibly powerful committee that picks our nation's judges.
To really understand this conflict, you have to meet the gatekeepers of the Philippine judiciary, the Judicial and Bar Council, or the JBC as it's known.
So what exactly does the JBC do? Well, its main job is absolutely crucial. It was created to act as a filter, to take the raw politics out of picking judges. The whole idea is to make sure candidates are chosen based on their merit, not on who they know. Now, the Constitution was incredibly specific about the JBC's size. It set the number at 7 members. And you know that odd number? That wasn't an accident. It was designed that way on purpose, specifically to break any potential tie votes and avoid deadlocks.
But here's the twist. For almost 20 years, the JBC didn't have 7 members. It had 8. This created a kind of constitutional imbalance that just went completely unchallenged year after year, until a high-stakes vacancy for Chief Justice in 2012 finally brought the whole issue to a head.
So you're probably asking, how on earth does that happen? How does a 7-member council just quietly become an 8-member one without anyone raising a red flag? Well, let's trace the history here.
You know, it all started out pretty logically. A single, alternating seat for Congress. But then, things started to shift. By 1994, you suddenly have 2 representatives, but they had to share 1 vote. Then, in 2001, came the game changer. Both representatives were suddenly given a full vote each. And just like that, the JBC's fundamental structure was changed, setting the stage for that big legal showdown in 2012.
Okay, let's get into the real meat of the legal battle, because this entire massive case really boils down to how you interpret just one little phrase in the Constitution.
And here you can really see the two sides of the coin. It's a classic showdown, isn't it? On one side, you have a strict, literal, read the words on the page argument. And on the other, you have an argument based on the practical reality of our government, which has a 2-chamber Congress. One side says A means 1, end of story. The other side says Congress is made of 2 distinct parts, and both need a seat at the table. The petitioner, Francisco Chavez, his whole argument was that the words of the Constitution are not suggestions, they're rules. If the text says a representative, then it means exactly 1, period. He claimed the language was so plain and clear there was absolutely no need to look for any hidden meaning. But the members of Congress on the council, they fired right back. They argued that Congress isn't just one monolithic thing. It's the Senate and it's the House. They are separate and distinct bodies, and to give a seat to only one would be to silence the other, basically disenfranchising half of the entire legislative branch. So with 2 really compelling arguments on the table, it was a genuine constitutional puzzle. All eyes turned to the Supreme Court. How in the world were they going to solve this?
Well, the court did not mince words. Their decision was swift, it was direct, and it was a big one. They declared that the 8-member composition of the JBC was, flat out, unconstitutional. So let's break down why they decided this. First, they leaned on a core legal principle, verba legis. It basically means you stick to the plain words of the law. The court said the text was unambiguous. They also highlighted the beautiful symmetry the framers intended: 1 representative from the executive, 1 from the legislative, and 1 from the judicial. Giving Congress 2 seats would completely throw that balance out of whack. And finally, they pointed to practical wisdom. An odd number just works better to avoid tie votes.
But, and this is a really big but, it wasn't a unanimous decision, not by a long shot. In a powerful dissent, Justice Abad argued that sticking to a strictly literal interpretation here was, well, kind of absurd. He reasoned that since Congress is bicameral, with 2 separate and distinct houses, a single representative could never, ever really represent the whole.
Okay, so a court ruling is one thing, but what does this actually mean? What are the real-world ripple effects of this decision for the justice system and for the country?
Well, the decision immediately kicked up this huge, frankly terrifying question.
If the JBC had been operating unconstitutionally for nearly 2 decades, did that mean that the hundreds of judicial appointments made during that time were illegitimate? I mean, the potential for absolute chaos in the judiciary was immense.
So, to prevent the entire judicial system from imploding, the court pulled out this legal safety net called the operative fact doctrine. Think of it this way. Even if a rule is later found to be wrong, you can't just undo everything that happened while everyone believed the rule was valid. The court said that JBC's past actions had real-world consequences that couldn't be erased, so all those prior appointments were allowed to stand. Whew.
Ultimately, when you strip it all away, this ruling was a powerful statement about the rule of law. It reinforced that the Constitution is the supreme law of the land, and it protected that delicate balance of power, ensuring that one branch of government doesn't get a disproportionate influence over another.
And what's so brilliant about this is that the court itself basically said, look, our hands are tied by the text. The only way to change this is to amend the Constitution. And that leaves us with a provocative question that's still being debated today. Should the Constitution be changed? Should it be updated to reflect the reality of a two-house Congress? It just goes to show you, these constitutional questions are very much alive and well.